In the first module of this section, all on employment law, we're going to be covering independent contractors. We're going to break this module up into two pieces. What is an independent contractor and some general legal notes as to how to deal with independent contractors. And then in the second part, we're going to jump into the actual agreement that you're going to be having with your independent contractors. So now we understand that in today's economy, especially with small businesses, independent contractors are highly utilized. They are an essential component of a small business, especially a business where there is a single entrepreneur and they're simply just outsourcing a bit of the work, supplementing what they are doing as they're running the ship on their own. So let's jump in and let's cover all that you need to know. Similar to the other sections, I've compiled notes that you can follow along on screen or refer in your own time that you can download, where we're going to discuss some of the bird's eye view legal issues with independent contractors. So first, a word on independent contractors. Typically, they charge fees for their services. They're engaged only for one time, required to perform an identified service or task. They retain control over the method and manner of their work, and they retain what's called economic independence. They're responsible for paying their own income, Social Security, and Medicare taxes, and they are not protected by most federal, state, or local laws intended to protect employees. So to build off of that, what are some of the benefits of engaging an independent contractor? So some of these are ensuring that the provider retains independent contractor status and not employee status, that the company is generally not liable for the negligence of independent contractors outside of a few specific instances, which the clients of Founders Counsel usually don't have to worry about those instances. You can deduct 1099 payments from the company's income. The company is not responsible for employer-provided benefits. These are Social Security, Medicare taxes, state unemployment insurance, and compensation insurance. Enhanced staffing flexibility is another huge benefit of retaining independent contractors, as well as reducing the exposure to employment lawsuits, because remember, independent contractors are not protected by the same lengthy employment laws. These are employment discrimination or wrongful termination suits outside of racial discrimination. Now, a big thing that we're going to be focusing on throughout this entire module is the consequences of what's called misclassification. Employers bear the burden of demonstrating that a worker is properly classified as an independent contractor. The penalties for doing this incorrectly and stating that your employee or treating them legally as an independent contractor as opposed to an employee are penalties, which may be back pay, employee benefits, disability payments, and workers' compensation, tax and insurance obligations, liquidated damages, and even civil monetary penalties. I cannot stress enough how important it is to make sure that you are properly classifying your workers as independent contractors. So let's cover exactly how you can do that and some of the things you need to keep in mind during your employment relationship. So the common tests for independent contractor status. Under the FLSA, which exempts independent contractors from employment law protections, an individual's specific work circumstances determine their employment status. Courts often use a balancing test, where they're going to weigh certain factors such as the degree of control the company has over the worker performing the services. A good thing to keep in mind is the contractor controls the work, the employer controls the result, or the company controls the result. Relative investment in facilities and equipment. So this means that the independent contractor is not invested in your company's resources. The worker's opportunity for profit and loss. So when you retain an independent contractor, you aren't giving them some sort of profit sharing arrangement or creating an arrangement where the amount of money they can earn depends upon the relative business success of the operation. Another factor is permanency of the relationship. So this is going to be the time that the relationship occurs for. So oftentimes, as we're going to discuss when we jump into the agreement, you want to make sure that the relationship is for a fixed duration of time and not for an indefinite period. Another factor is the skill level required and the degree of independent business organization and operation. So this means that the independent contractor essentially runs their own mini business. It's not dispositive whether or not they operate under an LLC, so make sure to keep that in mind as well. And another big factor is their ability to market their services to other customers. So you cannot retain sole economic control over that independent contractor, aka saying they can only work for you and they cannot work for other competitors, which we will discuss in the agreement. And that's going to be a business decision that you may want to make, but it's going to tilt that scale to the side of employment status rather than independent contractor status. So then the IRS applies a different standard for tax purposes. So remember about the 1099. It could be beneficial for a company to deduct the independent contractor's 1099, but the IRS is going to look at this again through a different microscope, determining whether under their status for tax reasons, the independent contractor is in fact an independent contractor. So oftentimes for federal tax purposes, the IRS is going to look at three factors: a behavioral control factor, financial control, and the type of relationship. Under the behavioral control, this is going to be the type and degree of instructions given regarding the work performance details, or how the work is to be completed. So remember, independent contractor controls the how, the company controls the result. Financial control, they pay their own expenses and they're paid a set fee for the project or service, as well as their ability to market their services to the marketplace at large. They're not beholden to only working for your company. The type of relationship, so having a written contract, whether benefits are given, whether the relationship is permanent or on a set duration of time, and whether the service is a key activity of the business. So remember, while an agreement is important to determining independent contractor status, it is not going to be determinative in of itself. So now with a bit of that out of the way, hopefully you guys better understand how to classify your independent contractors and how to govern that relationship to ensure that you don't run the risk of misclassification. So now let's jump into the actual agreement itself. Let's discuss the agreement itself. So guys, if you take a look at the screen, I'm going to have on one side the notes and a discussion of the agreement. And then on the other side, you can watch me actually going through the agreement and filling it out myself. You guys can follow along and do the same self-servicing for your own document. Remember, very easy to fill it out on your own. Just take a look at the bold and highlighted text and fill in your own customized information. All on your own, no attorney involved. I do want to make a quick note about attorney involvement. So one of the benefits of self-servicing your own documents and having all of these documents yourself is that even in the event that you still want to involve an attorney, you're going to drastically reduce the amount of hours that attorney is going to have to work on your case, because all they have to do is review the document that you've already done. They don't have to prepare their own document, do their own internal research. It's just there, and you limit the scope of their work to simple review. And a lot of attorneys will provide document review service. If you are looking for this, simply contact us and we'll put you in touch with our affiliated attorneys. The agreement is going to be between a self-employed individual and your company for the performance of services. Use this agreement when hiring workers to perform specified projects for your business. These are going to be marketing services, web design, consulting. And now remember, when you're hiring an independent contractor and using them for a key service in your business, that's going to be a factor that starts to weigh a little bit closer on the employment side. So then you're going to have to make sure to take other steps to further hammer home the fact that this person is an independent contractor. One of those could be adjusting this agreement, as we're going to discuss, to take away, let's say, the non-solicitation provision. Independent contractor status is determined on a sliding scale, and no single factor is going to be determinative, not even this agreement. If an independent contractor performs a critical function in your business and you're paying them by the hour, create less restrictions in the agreement, as we are going to discuss, in order to enhance the likelihood that this person will be classified as an independent contractor in your business. The closer the relationship gets to resembling an employment relationship or an employer-employee relationship, the higher the risk of misclassification. Another note, remember, this agreement is based upon federal law, as is a lot of the things we discuss in this course. Now, oftentimes pro-business states will have a lot of the same laws. For example, a lot of pro-business states will model Delaware law. Two states to keep in mind that really kind of go their own way, especially in the employment area, are California and New York. So if you guys are located in California or New York, contact us and we'll get you in touch with some attorneys who practice out there in California. We here at Founders Council have affiliated attorneys who practice in New York, so we can take care of that for you. So Section 1 of the agreement is going to contain provisions that indicate the worker's status as an independent contractor. If parties enter into an ongoing engagement that are going to cover successive projects, or the engagement is repeatedly extended, parties should evaluate whether the contractor is in fact an employee. Always understand and appreciate the nature of the consequences. After all, you as the business owner need to conduct your own risk-reward analysis, and it is only for you to determine how you want to engage in these relationships. It's only for you to be able to determine which factor is more critical to your business and on which factors you can give a little. For example, maybe you really want to be able to hire this person by the hour in an ongoing relationship. Well, then you're going to have to weigh the factor that maybe you can't restrict this person's business in terms of the non-solicitation provision or the confidentiality provision. We're going to cover this a bit more in the employee handbook, but remember not to include rules and procedures that are characteristic of an employment relationship. Another note, pay periods should be by accounts payable and not on payroll. Section 2 of the agreement provides for a fixed term, typical of an independent contractor relationship. An indefinite term that can be terminated at any time for any reason is more characteristic of an at-will employment relationship. Section 3. Payment on a fixed fee basis may support independent contractor classification, rather than based on the number of hours worked. Employees are typically paid by the hour, week, or month. Ensure independent contractors are going to carry their own expenses. While they may pass that cost onto the company as part of the fixed fee, reimbursement is commonly a right reserved only for employees. Moving on to Section 4. Remember, while labels that the parties attach are not dispositive, the company should include this clause as evidence of the parties' intent surrounding the relationship. That intent being one of a company and independent contractor relationship. The waiver of Section 4.2 ensures that in the event of misclassification, the independent contractor has waived their right to obtain or participate in any company benefits. The indemnification ensures that the company will not be liable for any taxes or contributions because of misclassification. Rather, the independent contractor will. If the independent contractor is represented by counsel, it is likely they're going to object to this indemnification provision. So keep that in mind. This is going to be a huge defense and a huge benefit for the company and a huge stick for the independent contractor. So it is likely that some objection could occur in this area. Section 4.2 also indemnifies the company against any claims based by or against an employee or contractor of the independent contractor. This is something that you're going to want to keep in. It basically says, look, you as the independent contractor are legally responsible for any liability created by your own employees or independent contractors. Their liability is not going to be imputed to us, the company. Section 5. Intellectual property rights arising out of the provision of the services will belong to the independent contractor automatically, but unless otherwise agreed to in writing by the parties. So that is what this agreement seeks to accomplish. This section ensures that the company will retain intellectual property ownership. A state like California may impose different or additional restrictions on an intellectual property assignment provision. Among other things this section does is to ensure that the independent contractor's employees and contractors are bound to the same effect, that's going to be in Section 5.7, and that the independent contractor will assist the company to maintain and defend the intellectual property that is created as a result of the contracted for services, see Section 5.4. These are basically just additional provisions that are going to say, not only do we have rights to the intellectual property created as a result of this relationship, but you as the independent contractor need to take steps in order to allow the company to enforce these rights to obtain their intellectual property. Now moving on to Section 6, the confidentiality section. So regarding Section 6.1, you know your company best. You know what information you want protected. You know what information is vital to the company. So you're going to see that this is an area where you should take customization and fill out information that is going to be important for you guys to keep protected at the company. While independent contractors do not have a legal duty to maintain confidentiality of the company's information, The company may include contractual confidentiality obligations in order to protect information that the contractor may have access to or develop during their engagement, such as trade secrets surrounding certain operations that are unique to the company, which they may want to safeguard. So for example, let's say your company is engaging someone for marketing services. You may want to have a confidentiality provision in the independent contractor agreement to say, hey, look, while you're marketing our services, we're going to be in contact with you and giving you a lot of trade secret information surrounding our company, specifically the way we do business, our operations, some of our tricks to, let's say, increase profits or increase revenue. And that might be something that you don't want your marketing service provider knowing. So even though they need to know it for the engagement, you want to make sure they are bound by this agreement to say that they cannot share this information with others. During the commercial contract session, we're also going to have an entire NDA agreement. So that can be something you can use in addition to these other agreements in order to ensure that your confidentiality is going to be protected. That agreement is far more lengthy, far more in depth, and we will cover it when we get there. Keep in mind that binding an independent contractor to confidentiality restrictions may be viewed as characteristic of an employment relationship. You must keep this in mind when weighing out the various factors in evaluating independent contractor classification. So determine whether or not confidentiality is very important to your business. If it is, then it's going to be something that's worth including. If it's something where you can give up on and there are other areas where you really want to hammer home, then focus there. Let's say, for example, the fixed relationship based on hourly payments, because doing it on a project basis might not be efficient for how your business operates. Moving down to section 8, as we discussed, indemnification is often a highly negotiated provision. In short, what is indemnification? Indemnity is a contractual obligation of one party to compensate the loss incurred to the other party due to the acts or omissions of that party or associated parties, such as, let's say, that party's employees, independent contractors, or personnel. This provision indemnifies the company for death, personal injury, and property damage resulting from the independent contractor's acts or omissions, as well as an indemnity for the independent contractor's breaches under the agreement. Remember, an independent contractor who is either savvy or represented by counsel is likely going to object to this provision, as you should if someone makes you sign an agreement. So keep that in mind. It goes both ways. If you are doing business with someone and they want you to sign an indemnification provision, carefully review that and raise your own objections. Section 9, the insurance section. The independent contractor does not need to follow this section, or any section of this agreement for that matter. However, if they do not follow it, then they are in breach, and it is ultimately up to you whether you would like to notify the party and seek to enforce your rights. If you believe this section is to be too burdensome, a lot of independent contractors might not carry insurance, especially smaller ones that engage on smaller projects. You can simply choose not to enforce it. You don't have to take it out entirely of the agreement, but you will at least still have the option to enforce it. But let's discuss why it might be important to include this. And it relates exactly to the reason why independent contractors might not carry insurance. Insurance may be beneficial because oftentimes an independent contractor lacks sufficient assets to back up obligations under the agreement, and they may be judgment proof. AKA, even if the independent contractor does breach the agreement and you sue successfully and obtain a judgment, you may not be able to collect against them. Insurance can ensure that the independent contractor will be able to cover any of their liabilities. Tying this back into earlier parts of the course, this talks about the importance of the limited liability company that separates your business's assets from your personal assets. So if a judgment is obtained against the business, let's say the person holds personal assets, well, if you obtain a judgment against the business and they're protected by the limited liability company or the corporate form, you will not also be able to obtain against the person themselves. The termination section, or section 10. If you are going to keep in section 10.1, setting out the ability for termination without cause, edit this language in order to make sure it's mutual, as a reciprocal right is more characteristic of an independent contractor relationship. When you're finalizing this agreement for yourself, do a final check on section 10.4, accounting for any removed sections, So let's say you take out some of the sections because you determine that that might be something you don't want to increase your liability on relating to misclassification. Make sure you go back to section 10.4 and edit the survivable provisions to account for any provisions you may have taken out. Sections 11 and 12 are subject to removal, as we're going to discuss right now. Section 11 is the section governing other business activities. This sort of resembles a non-compete, but not quite. We're going to discuss a non-compete during the employment agreements. For section 11, this is a section that's going to be something that may potentially shift the scale a bit closer to the side of employee classification. The company should not restrict an independent contractor's ability to take on other work during the term of engagement because the contractor's ability to work for other clients is characteristic of independent contractor status. Remember, that was directly part of those tests that we discussed in the beginning of this module regarding the financial control and the economic control of the independent contractor's own business. A particular state like California may be especially hostile to this provision. So again, it's up to you as the business owner, the personnel, or the management to determine whether or not this is something that you want to keep in your agreement. How important is this non-solicitation clause to you? We are not going to tell you affirmatively to do or to not do something. We are here to provide you with the information to equip you in order to make the best and informed decisions on your own. We believe it's important for you to be equipped with this knowledge in order to make your own decisions because at the end of the day, only you know your business. You know your business better than any attorney or better than any outsider. You know what areas are going to be most important for your business to keep and which ones you can have some wiggle room on or give up entirely. Section 12, the non-solicitation provision, is another section that's going to suggest that the company controls the activities of the independent contractor and is going to support a finding more towards employee classification. The company, again, must weigh the commercial reasons for including this non-solicitation clause. The company could make the non-solicitation clause mutual by replacing the language to, instead of you, with both parties. Placing the restriction on both parties reduces the chances of determining employee classification. So that goes back to the idea that within your agreement, you can make little tweaks in order to get that scale going a little bit closer to the independent contractor side. The assignment section, or section 13, indicates that the independent contractor may not assign any rights or delegate or subcontract obligations under the contract without the company's consent. This means that if you contract with a certain service provider, you do not want them then going and assigning the contract to someone else and having them do the work. Why? Because you signed this contract with them so that they do the work, not someone else. You wanted their skill and expertise. So now section 14, or the injunctive relief provision. This may be included to address breaches of specific provisions like the confidentiality and the non-solicitation, if the business reasons merit including it. So injunctive relief, as opposed to monetary damages, is a request to the court in order for the court to state that the party needs to either do or not do something. Injunctive relief is a legal remedy that forces the party to act in a specific way or forbids them from engaging in certain activities. Injunctive relief may be used to force parties to adhere to their obligations under an agreement. So for example, let's say you have your confidentiality agreement with someone and they start going on social media and either disparaging your company or sharing some of the operational secrets that you guys want to keep confidential. Well, now you can go to a court and request injunctive relief and have a court state that that person must immediately cease doing what they are doing. Note that it is ultimately up to the court whether or not to grant injunctive relief, and this agreement is not going to be dispositive of that. However, it will help. Section 15, or the arbitration section. So now let's talk about what arbitration is. So arbitration is a form of alternative dispute resolution where the two parties agree not to take their dispute to court, instead opting to hire an arbiter to hear both sides. The arbiter will issue a decision that is binding and may be enforced in any court. An attorney does not need to represent you into an arbitration, and an arbitration clause is common in many consumer, employment, and other business contracts. So now, while an arbitration clause does sound great, and it's an automatic stick for the opposing party to say that we are going to handle these disputes in arbitration, which is usually beneficial to the business owner, let's discuss the benefits and the drawbacks. The benefits are speed and informality. It's private and it's not going to be public record, and there is no lengthy discovery process, which is often where attorneys and law firms make their money. It acts as a stick, and typically parties will split the costs of arbitration. However, the drawbacks are that you cannot appeal the decision. So if you get an adverse decision, that other party is going to be able to then go to the court and enforce it, and you can't appeal it. Also, the exchange of information is going to be limited. There are times in disputes where you may want a lengthy discovery process. Perhaps there is information that you know the other side is hiding, perhaps in a computer somewhere, and you want to make sure that that comes up and is used in court. Oftentimes, the location that you choose for arbitration will be respected. Now, that is unlike Section 16, which sets out the governing law, jurisdiction, and venue when you want to enforce, for example, the injunctive relief provision where you have to actually go to the courts to do it. Section 16 pertains to Section 6, confidentiality, and Section 12, non-solicitation. So for location, you want to choose a location that bears some relationship to the parties or the transaction. So where the parties are located, where the work was to take place, where the transaction was negotiated and signed. Unlike the arbitration provision, a court is not going to automatically accept your dispute simply because you put it in an agreement. There has to bear some sort of actual relationship. What courts will do is they'll often engage in what's called a reasonability test. So now moving on to Section 17, you're going to be seeing this in a lot of different agreements. These are called the boilerplate provisions or the standard provisions. You guys will see on screen how I fill those out. Pretty easy, pretty standard, not a whole lot to worry about there. Signature page follows, you're going to engage in your signatures. And then so Schedule 1, let's discuss Schedule 1. So the benefit of having Schedule 1 is to detail the variable terms of each specific agreement. So you can take the agreement as a whole and use that in multiple engagements and then make more detailed adjustments to Section 1 or Schedule 1, where you're going to actually detail the services that are being provided, the access provided. You're going to detail the payment schedule, any deliverables, any pre-existing materials that the independent contractor may be coming into the engagement with, and as well as a benefit waiver. So that's going to say that the independent contractor is not entitled to any company benefits. So that covers independent contractors as well as our agreement for our independent contractors. I understand that we covered a lot here and there was more legal terms, so either refer to your notes or give this module another review. I do believe that this module is going to pay huge dividends for your company, so give it a few watches and really absorb this information, and we can't wait for you to start using this agreement in your own practices.